Hey, good evening, everybody, and welcome to the New York State Trustee Handbook Book Club. I'm your moderator for the evening, Brian Hildreth, and I'm excited to be here with all of you tonight as we dive into Freedom of Information Law, otherwise known as FOIL. For those of you who are joining us for the very first time, Trustee Handbook Book Club exists to empower New York's 6,000 plus library trustees with the knowledge and tools that you need to excel in your governance role and champion for your communities. Before we jump into it, let's get to know each other a little bit better. Everybody's been already chiming in as we've gotten started. Please drop a quick intro in the chat. You can enter your name, which library you serve from, and how long you've been on your library board. It's always fun for us to see where everybody's zooming in on this nice cold winter evening. Tonight's session is made possible through our partnership with the New York State Library, the Public Library System Directors Organization, the Library Trustee Association, and the Public Library section of NYLA. We are grateful for their continued support and bringing these valuable learning opportunities to trustees across New York State. Here's our agenda for the evening. First, we'll explore tonight's topic with our expert presenters. Then we'll tackle your pre-submitted questions. Following that, we'll open it up for live Q&A for real-world experiences and questions always make for the best discussion. On a quick tech note, please use the Q&A button at the bottom of your screen for questions, and feel free to share your thoughts and experiences on the chat. Supporting us tonight is our ever helpful Laura Chrissy from the Mid-Hudson Library System. She is our technical support and will share out information and links as we go through the night in the chat section of Zoom. I'm also pleased to introduce our THBC leader, Rebecca Smith Aldrich. Rebecca serves as the executive director of the Mid-Hudson Library System, where she has worked for over 25 years to help the libraries of the Hudson Valley become more viable, visible, and vibrant. She's also the co-author of the Handbook for Library Trustees of New York State and the Public Library District Toolkit, which can be found on the New York State Library's website. As well as being the author of the Handbook for New Library Directors of New York State, Rebecca is the co-founder and president of the award-winning Sustainable Libraries Initiative and the principal author of National Climate Action Strategy for Libraries. In addition to her work as an adjunct professor at Long Island University, teaching as a postgraduate program on public library administration, she is also the author of several books, including Sustainable Thinking, Ensuring Your Library's Future in an Uncertain World, and Resilience, which is part of the ALA's Future series. Furthermore, we are happy to welcome Kristen O'Neill for a third time on THBC. Kristen is from the Committee on Open Government of New York State. It's fantastic to have Kristen here with us to help us better understand the Freedom of Information Law, or also known as FOIL, and how we can be good stewards of taxpayer dollars, maintain government transparency, and protect the long-standing public trust that public libraries have worked so hard to earn. Rebecca, Kristen, thanks so much for being here with us tonight.
Thank you. Thanks for that introduction, Brian. We're thrilled to have Kristen back with us again this month to take a deeper dive into the Freedom of Information Law. A lot of us think of that as FOIL, and a lot of us live in dread of getting a FOIL request. And so one of the things that we try to do is make sure we just confront those things that we don't feel that confident about in our library. So this is a nice opportunity to get the lay of the land of the law, what policies and procedures you should have in place at your library. So if a FOIL request comes in, it's demystified, you know what to do, you know what timing you have to hit to get this right. So Kristen has been kind enough to come back for the second time in 2 months to talk to this group to make sure we have the information we need to, as Brian said, uphold the letter of the law here, because it's one of the key elements of being a transparent governing board. Making sure that if folks have questions, we're getting them answers. And if they want to take a deeper dive in something and it's a document that we have on hand and is reasonable to share, that we're doing so as per the letter of the law. So I encourage you to listen carefully to what Kristen has to say. Just a reminder, you're going to get a copy of the slides. You'll have access to a recording of this. And yes, you will get a certificate of attendance, maybe not, 2 minutes after the event, but you will get one. So as always, we thank you for your patience. Again, questions into the Q&A feature in your menu bar at the bottom of the software. And we'll look forward to seeing what questions you have once Kristen is done. But I'll hand things over to Kristen, who is really one of the top experts on this law in the entire state. We're so lucky to have her here today. So thank you, Kristen.
Thank you, Rebecca. So we'll get started today. For those of you that may have attended a couple weeks ago, I'll let you know that I'm in my office today. I'm not at home. We will not have any kittens jumping up on the back of my of my chair or dogs barking in the background. Hopefully, it should be a quiet, peaceful presentation this week. So today we're going to talk about the New York State Freedom of Information Law and what a public library's obligations under that statute. Let's see. Anyways, for some reason it always doesn't go quite as smoothly as I would like it to, but hopefully it'll work out maybe even a little bit better than a couple weeks ago. Brian introduced me as Kristen O'Neill. I will still answer to Kristen O'Neill, but I did get married back in October. And so I made the crazy decision to go about and change my name, which, is a lot more work than I remembered it being. But anyway, it's a done deal now. But anyway, as I said, my email address hasn't changed. So if you have my email address and you want to continue to reach out to me, it's still going to be Kristen O'Neill. I will answer to either name. If you'd like to reach out to our office, we do have other attorneys on staff. In addition to myself and our executive director, we have 2 senior attorneys. So if you ever have questions about freedom of information law or the open meetings law, you can call the number you see up on the screen right now, or you can email that email address, that coog@dos.ny.gov, and then the first attorney that has an opportunity to do so will get back to you. And always keep in mind, we have lots of information on our website, which is opengovernment.ny.gov. We keep an up-to-date version of the statute available on our website, regulations, advisory opinions. If there's anything new and exciting in the world of open government, we put that up on our website. This is what it looks like in general. There's some drop-down bars at the top of the screen, but where you see a picture of the Capitol building there is where you might see any new updates. If you've heard rumblings, perhaps that there was an update to either FOIL or the open meetings law, this is a good place to start at to look. So today we're going to talk about FOIL, and it's been a little while since, I shouldn't say it's been that long since I've done a library presentation, and of course I neglected to skim through to see where I may have put certain things, but I'm going to preface this by a couple of weeks ago, we talked about the open meetings law, and whereas the open meetings law applies to both public libraries and not-for-profit association and free libraries, freedom of information law only applies to public libraries. Free and association libraries want to voluntarily make their records available, that's fine, but freedom of information law does only apply to public libraries, not the not-for-profit libraries that are commonly known as free or association libraries. The statute's been around since 1974, and that's when our group was created, the New York State Committee on Open Government. There is an 11-member body that constitutes the Committee on Open Government. Our executive director and her staff carries out the day-to-day activities of the Committee on Open Government, but there is in fact a body that meets a couple times a year. They agree on an annual report to the governor and the legislature about any amendments to the statute or improvements to FOIL or the open meetings law that they think are appropriate. So as I said, it's been around since 1974. The original version was much different than what we have now. That was repealed and replaced with what is essentially the current version of the statute. And that's where when someone makes a freedom of information law, when a government agency receives a freedom of information law, there's a presumption of access. So when a FOIL request is received by a government agency, such as a public library, they should start with the assumption that all records in their possession are subject to rights of access under the Freedom of Information Law. And then you get to step back and take that second review to determine whether the record itself or any portion of the record fits into one of the permissible statutory grounds for denial. Who is covered by FOIL? The term used by the statute is agency. So you'll hear me use the word agency over and over again. So under the Freedom of Information Law, an agency is any state or municipal, department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function. Who's not covered by FOIL, let me rephrase that. Who's not an agency subject to obligations under the Freedom of Information Law? The courts. So not that many court records aren't publicly available, but you can't make a FOIL request to the courts. You can't make it to town court or village court, city court, state court. county court, it doesn't matter. FOIL is not the appropriate mechanism for obtaining those records. And while there is a provision in the Freedom of Information Law that establishes rights to certain records of the New York State Legislature, they're not a government agency in the same way all other entities are. There's no presumption of access to records of the state legislature. Specifically for this presentation, as I mentioned earlier, I couldn't remember whether I'd said it, so I wanted to make sure I did say it, that only public libraries are subject to FOIL as opposed to free or association libraries. And as I mentioned a couple weeks ago, the same is not true for the open meetings law because there's a provision of the New York State education law that mandates compliance with the open meetings law for all libraries. The same is not true for the Freedom of Information law, so only public libraries are subject to FOIL. Every agency subject to FOIL is required by statute to have a policy, a FOIL policy in place. And we have a model policy on our website, if that's helpful to you, if you've gotten away for the past 50 years without having a policy, or maybe you do have a policy in place, but you think it's probably a little bit dated. It may be worthwhile to take a second look at it to make sure it's compliant with the current obligations under the statute. So we do have model policies on our website, that opengovernment.ny.gov. One aspect of that policy is a designation of a records access officer. So by law and regulation, every agency subject to FOIL has to appoint at least one person, can be more than one person, but at least one person as records access officer. That records access officer is the point person, the coordinator of responding to FOIL requests. They are clearly not the only person within the library or the library system that is required, that has statutory obligations under the Freedom of Information Law. The Board of Trustees is going to have some level of statutory obligation under the Freedom of Information Law. Your library director may have some level of obligation under the Freedom of Information Law. The records access officer is the point person. They're the one who has been given the lovely responsibility of receiving the FOIL request, gathering the records themselves, or reaching out to the appropriate staff members to gather the records to then determine rights of access. That designation has to either be by name or by specific job title. So depending on your structure, you may have a specific position within the library that it just makes sense that this person always should serve as records access officer. So your policy might say that our business officer is our records access officer, our library director is our records access officer. That's entirely at your discretion, but the designation has to include a business address and an email address for where the public can send their FOIL requests. What is a record? When we talk about access to records, the Freedom of Information Law is somewhat of a misnomer because it's not about access to information, it's about access to records. And it means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. So as you can see, it is incredibly broad. If you can see it, if you can hear it, if you can read it, if you can touch it, it's likely going to be a record subject to rights of access under FOIL. It doesn't matter, whether it's a record that you're required by law or regulation or policy to create and maintain. Once you create it, once you have it, it's a record subject to rights of access under FOIL. Now, when I say that, just because it's a record that's subject to rights of access under FOIL doesn't necessarily mean it needs to be disclosed. It just means that you have to at least consider, you start with that presumption of access. Yep, we have it. We have this record. It's subject to rights of access under FOIL. And then you look to see whether any of the statutory grounds for denial will apply. So you can keep in mind that when you receive an inquiry or a Freedom of Information Law request, FOIL does not obligate agencies to answer questions or to manually create new records in order to provide information. So for example, if someone comes to the library and says, well, why haven't you, why is your, historical romance section so chintzy? That's just, you're not obligated to answer those questions. You're not obligated to manually create a new record in order to provide the information that somebody is asking for. Keep in mind, making a copy of an existing record does not constitute creating a new record. I know this probably seems like common sense, but for a while we had this real pushback from some agencies who felt that, for example, if a record just existed in paper form, it's an older record, all it was is the only medium that it existed in was paper. And someone would ask, I would like you to scan that record and send it to me as a PDF. The law says that that is not the creation of a new record. That's merely making an electronic copy of an existing record. So making a copy in another format is not creating a new record. It's just making a copy of an existing record. This extends to data extraction. If you have information that is contained in a database and you have the ability to query that database and produce a report that contains the information that is being requested by the applicant, the law specifically states that that shall not be deemed to be the preparation or creation of a new record. So even if it's not a report that you prepare in the regular course of business, if you can query the database, if you can, type a little, some questions into the database and hit print or hit export or whatever the word is, and it'll produce those data elements. The law specifically states that is not considered to be the preparation or creation of a new record. Finally, this is somewhat goes back to the idea of the scanning, as there's a specific provision of the statute that says an agency is required to provide records on the medium requested by the person if they can reasonably make that copy or have that copy made by engaging in outside professional service. So this may go to the question of scanning versus photocopy. It may go to the question of whether if someone would prefer a record be provided to them in Excel or Word as opposed to PDF. If you're able to provide them the record in an original Excel format or an original Word format, and that's the format that they want it in, that is what you'd be obligated to do. There are 3 records, as with every rule, I said that you don't have to create new records, but as with every rule, there's exceptions. The 3 exceptions under the statute is that every agency is required to maintain a record of the votes of their public bodies. So it's a record of the votes of every member in all of their sessions and all of their committee and subcommittee meetings where the member votes. So if your library board of trustees, whenever they have a meeting, of course, they have to prepare meeting minutes as required by the open meetings law. But in addition, there's this extra provision that exists under the Freedom of Information law that you have to have a record of how each member voted. If you have a 7-member board of trustees and a resolution passes unanimously, that's really all that the minutes would need to say, the record would need to say, because clearly if everyone voted the same way, it's easy to figure out how they voted. But on the other hand, if you have a resolution that passes 4-3, you have to maintain a record of who voted in favor of the resolution and who voted against. So while the open meetings law, which simply required that your minutes say this resolution passed 4-3, there's this provision of the Freedom of Information law that requires you to have a record of how who voted in favor, who voted against. The second record that every agency is required by law to maintain is a record setting forth the name, public office address, title, and salary of all your officers and employees. So again, this is public office address. It's not home addresses. You do not need to disclose home addresses, not even of your trustees. So if all of your employees and officials, if their place of work is your library, that's what this record would say. It would say the name, where they work, the physical address where they work, what their title is, might be a civil service title, or it might be an appointment title, might be the title that they are a library trustee, and what their salary is. So that's a record that every agency is required to maintain and make available upon request. And the third record is a reasonably detailed subject matter list of the records your agency maintains. I don't know that this is useful for libraries. It may be, because I'm not actually overly familiar with the record retention and disposition schedule put out by the New York State Archives. But if you find it useful to adopt that record retention and disposition schedule, at least in part, because it matches up nicely with the types of records that you as a library maintain, it might need to be tweaked a little bit because you're not a city or town or village government. You're not a school district. Your records are going to be a little bit different. There's probably a lot of crossover. So it might be, at least if you don't have a subject matter list, it might be a good jumping off point. So those are the three records that FOIL requires that you maintain. When an applicant submits a FOIL request, they don't have many responsibilities on their part, but what they do need to do is they need to reasonably describe the records that they are seeking. What does this mean? Essentially what it is have they provided you with sufficient detail to allow you to identify and locate the records that they are seeking? Part of it is, do you actually even understand what they're asking for? Are they using terminology that you're familiar with? Do you basically just get it? Yes, I understand what they're asking for. That's really the first basic gut level response. If you don't, the best thing to do is to engage back and say, it's not really clear what you're asking for. Can we have a conversation? Can we, discuss? Can you help me understand what you're asking for? The second aspect of it, you might understand what they're asking for, but they may not have given you enough detail to allow you to locate the specific record that's being sought. So, for example, you have a series of records that are maintained by date. Like there are certain, maybe perhaps financial records that are maintained by month and year, and that's the filing system that you use. But instead of providing you with a certain month and year, they've just asked you a general question about how much has the library spent on lighting over the past 10 years. I don't know, maybe you have a way of locating that information with reasonable effort. Maybe you have records that reflect that and it's not overly difficult to find that. But essentially, if you would need to dig through dozens or hundreds of records to extract the ones that are responsive while throwing aside many other records that are not responsive, then they may not have reasonably described the records sought because they haven't given you enough detail to allow you to locate the records that they're seeking with reasonable effort. I'll give you an example that I used to deal with at the Committee on Open Government. All government agencies subject to FOIL are required to provide our office with copies of any appeals and appeal determinations that they receive and that they issue. You can email it to us, you can mail it to us, but say 10, 15, 20 years ago, all of those appeals and appeal determinations were coming in the mail. And we would review them, we would look for any red flags, but after we reviewed them, they would basically get placed in a filing cabinet based on the month and the day, month, and year that they were received. They just basically, every day, we would just add to the filing cabinet in the order that they were received. So if someone came to us 20 years ago and said, I'd like a copy of a FOIL appeal determination that was received by your office on February 10th, 2006, yes, we would be able to locate that. On the other hand, if someone had come to us 20 years ago and said, I'd like a copy of all FOIL appeal determinations issued by the city of Albany, we would have had a really tough time doing that because that's not the way we filed our records. We didn't have a log. We just, we didn't have a great record keeping system 20 years ago. However, we've gotten better, and so now if someone came to us with that same question, we'd be able to locate the record. So hopefully that gives you an idea of what I'm talking about. Is can you locate the record with reasonable effort based on how you maintain your files? Would you have to search for a needle in the haystack to find the ones that are being asked for? Clearly, now that records are being maintained much more frequently electronically than they are in paper, 20 years ago, a lot of records were just paper records. 25 years, 30 years ago, it's all paper records. Now most of our records are maintained electronically, and it is a little bit easier to search when you have your records filed electronically. Time limits. So when your library receives a FOIL request, the first time limit that you want to keep in mind is 5 business days. You have to do something within 5 business days of receiving that FOIL request. You need to either fully respond to it, like for example, if it's something really easy, like someone's making a FOIL request for copies of meeting minutes from 2 months ago, that should be pretty easy. You should be able to turn that around in 5 business days. Perhaps they've made a FOIL request for copies of records that are confidential by statute, for example, records that are relating to library patron usage, like the books that they've taken out, or other things that were confidential under New York State. I think it's the civil practice law and rules, which I'll get to. I think I have a slide. Hopefully I have a slide on that to remind myself. But anyway, there is a confidentiality provision relating to a library patron usage, records relating to library patron usage. So if someone made a FOIL request for like that, it would be a pretty easy no. We're not allowed to disclose that information. You might be able to just turn that around and get it off your desk within 5 business days. Another option might be to say, we don't have the records you're asking for. Maybe they're asking for records that are maintained by another library. Maybe they're asking for records that are maintained by the town or the city or the county. They're just not your records. So a perfectly appropriate response might be, we do not possess the records that you're seeking. The fourth option is when you as a library deal with quite a lot of FOIL requests, or the specific FOIL request that you've received is voluminous or complicated, and it's going to take you more than 5 business days. So the first step is you get 20 business days from the date of acknowledgement. You don't have to justify why you need an additional 20 business days. You don't need to tell them why you need an additional 20 business days. You just need to send out within that acknowledgement letter, you need to notify them that you plan to respond by, and then you give them a date that is no more than 20 business days. If you do that, as I said, you don't need to justify yourself. There is wiggle room, though, for FOIL requests that are even larger, that are more voluminous, more complex. And in that situation, your agency, your library, can send out an acknowledgement letter that provides a date certain that is reasonable given the circumstances of the request. But when you do that, if you do need more than 20 business days, you do need to provide a brief explanation as to why you need more than 20 business days. It can just be something as simple as given the volume of your request. It could be given the volume of FOIL requests that we're currently processing. It's, whatever the reason is that you know that you're not going to be able to process that request within essentially a month, you just need to provide a brief explanation as to why, and then you give that date certain by which you plan to respond. If there's a reason why you need to deny access to a record, you need to put that in writing, and you need to advise the individual that they have 30 calendar days to appeal that denial. When your agency receives a FOIL appeal, your agency has 10 business days to respond to the appeal. Just keeping in mind that there is a provision in the statute 25 years ago, I think the law was amended. At that time, the law was amended to say if an agency is able to, it must accept FOIL requests via email. Essentially, we all know that that's pretty much a moot point at this time. All government agencies use email. Everybody uses email. So there's really would never be a reason why a library, a government agency, should not be able to accept FOIL requests via email. In addition, while there's nothing wrong with making forms available, whether it's a paper form, a fillable PDF, or a portal for submitting FOIL requests, it's perfectly fine to make those available to the public. You can't require that an applicant use those forms or portals. If they would prefer to simply send an email explaining what records that they're asking for, or send a letter asking for the records that they're seeking, that's all they have to do. Their only statutory obligation is to put the request in writing and direct it to the records access officer. They cannot be required to use your specific form. In addition, unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. So, for example, if someone's asking for a record that would be publicly available to anyone that asked for it, here I'm talking about things like contracts, financial records, things where the identity of the applicant is essentially irrelevant to rights of access. Under those circumstances, the person who's making the request should be able to remain anonymous. They might send an email from janedoe@gmail.com asking for a copy of a specific contract or a specific financial record. In that case, you get it, you probably have it electronically, you attach it to the response email, you send it right out, FOIL request done, end of story. There are, of course, circumstances where people ask for records that trigger personal privacy concerns. And if that's the case, yes, you would be permitted to, if they want an unredacted copy of that record, if they want a record, for example, that pertains to themselves, it's perfectly fine to require proof of identity. So here's where you're going to be relieved that we're going to be sharing slides with you, because I don't want anyone to feel like that they need to memorize everything that they see on these screens, because I'm going to go through, I'm not going to go through every one. I'm going to go through the ones that come up the most frequently. These are the statutory grounds for denial. If you don't see it in the statute, that means the record likely needs to be disclosed. So we'll go over the things that come up the most frequently when an agency has concerns about disclosing a record. If you have that sort of gut feeling, I don't think I should be disclosing this, there very well may be a permissible ground for denial set forth in the statute that you can point to when you issue that denial. So the first one is where a record is exempt from FOIL disclosure by either state or federal statute. So the example that I brought up earlier is library records. And I don't mean library records generally, because obviously what would be the point of FOIL if being able to FOIL a library if all library records were confidential. Here we're talking about library patron records reflecting library patron usage. What books someone has taken out, or what, maybe if they've used computers or anything like that, if they've booked a room or anything like that. There's a specific provision of New York State civil practice law and rules that makes that information confidential, and you can deny on that basis. Whenever there's a separate statute outside of FOIL, for example, the CPLR, for student records, like if someone made a FOIL request to a school district, a CUNY, a SUNY, a community college for a particular individual's student education records, those are confidential by statute. As I mentioned here, whenever a record contains somebody's social security number, you want to make sure you're redacting that before disclosing the record. I used to work for the Office of Mental Health. I was their records access officer. Sometimes we would get FOIL requests for psychiatric records. No, those are not available under the Freedom of Information law. They are exempt from FOIL disclosure by New York State mental hygiene law, by the federal HIPAA privacy regulations. The same would be true if it's a government-operated hospital, like SUNY Stony Brook has hospitals. There's other government operated hospitals where a person's medical records would be made confidential by a statute other than FOIL, another state or federal statute. If that's the case, that statute is always going to take precedent over the Freedom of Information law. So this is the provision I wiped. As I said, I was really bad. I didn't have a chance to skim through. I was rushing and I didn't have a chance to skim through it. I'm so happy that I was good about including a description of what civil practice law and rules covers. So it defines what library records are. It's library records which contain the names or other personally identifying details regarding the users of the library. So those are the records that are confidential. Someone is looking to see how any particular person has used the library. Those records that identify how any particular person has used the library are confidential. Unwarranted invasion of personal privacy. As I go forward, I'm going to point out that the rest of these grounds for denial are permissive. When a record is confidential by state or federal statute, you have to comply with that state or federal statute. It's mandatory. The rest of these grounds for denial are permissive, which means you can assert them, but you're not required by statute to assert them. So if you want to deny access to any information, any portion of a record because you believe disclosure would constitute an unwarranted invasion of personal privacy, for example, you are certainly permitted to assert that ground for denial, but you are not required to. It's not, you wouldn't be taking the position that we're prohibited from disclosing that information. You would just be taking the position that we are permitted by statute to assert this ground for denial. Some examples are if you have a job opening, 20 people apply for that job opening. The one person that gets the job, there's a lot of information about public employees that has to be made available to the public. So for example, my resume that contains my education, the fact that I have a law license, the fact that, all of my previous public employment history. There's a lot of information about my education, my work history, my qualifications that need to be disclosed to the public because I am a public employee. But if I'm simply an applicant for a job, someone has applied for a job but wasn't hired, any records that tend to identify the individual who applied but was not hired can be withheld. So again, applications can either be withheld in their entirety or redacted sufficiently to protect the identity of the individual who applied. If you have records that contain home telephone numbers or personal cell phone numbers of either your employees, your trustees, or members of the public, you are permitted to withhold that portion of the record. If your employees' personnel files contain any medical information, like for example, why they needed to take a leave of absence, or maybe why they needed a reasonable accommodation or anything of that nature, that type of information could be withheld on personal privacy grounds. Public employees' home addresses do not need to be disclosed. Those can be withheld on personal privacy grounds. Lists of names and addresses of natural persons, if that information is going to be used for solicitation or fundraising purposes, that is another time where a record can be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. And this is also really the only time you're allowed to ask someone why they want the record or what they're going to use the record for. In general, the identity of the applicant and what they plan to do with those records is completely irrelevant. There is no exception generally for commercial use. You can't deny a request just because the person plans to use the information for commercial purposes. This is a much more narrow ground for denial. It's specifically names and addresses of natural persons. In other words, library patrons. So list names of addresses of library patrons if the person would plan to use that information for solicitation or fundraising purposes. About a year and a half ago, the law was amended to require that all agencies create a policy that addresses how they will handle notification to their employees in the event that the agency receives and is responding to a FOIL request for that employee's disciplinary records. So, for example, you've got a library aide, someone makes a FOIL request for a copy of that individual's disciplinary record. You have to have a policy in place about when that notification is going to be made, how that notification is going to be made, what are we going to do if that person no longer works here. We prepared an advisory opinion that tried to address some of the questions that we received when the law was amended. If you would like to see that advisory opinion, just shoot me a note and I'll send it to you. Because what you see up on the screen right now, that's the entirety of the amendment. The legislature didn't give us a lot to work with. They didn't give us a lot of details. All they basically said was everyone has to establish a policy. How that policy, the details of that policy is up to everyone. But we did try to provide some guidance based on our understanding of the legislature and the governor's intent. I'm not going to worry too much about law enforcement because I don't think this comes up too much with libraries, but just keep in mind that there is a provision that allows an agency to withhold records if they've been compiled for a law enforcement purpose. Again, don't know that this comes up too much with libraries, and if disclosure would cause some type of harm. This ground for denial does probably come up a little bit more frequently, and it's called the intra-agency or interagency material exception. And what this is it allows a government agency to withhold certain records that reflect an agency's, either a single government agency or multiple government agencies' deliberative process. So maybe you've got staff members that are working together on a project and they're emailing each other back and forth with their ideas, their opinions, their recommendations about this project moving forward. Those emails do not need to be disclosed in general. If you're working on a draft policy that hasn't been finalized yet, that draft policy that hasn't yet been approved or finalized does not in general need to be disclosed. But this intra-agency material exception has exceptions to that exception. If someone makes a FOIL request for material that you would consider intra-agency material, what you are required to disclose is information that reflects statistical or factual information. That's the one that comes up the most frequently. So say you send an email to your supervisor with a recommendation about how to make an improvement at the library. So the portion of the email that reflects your recommendation could be withheld. But if you include with that in that email any sort of statistical data, factual information to support your opinion, to support your recommendation, that objective statistical factual information would need to be disclosed. What else needs to be disclosed? Instructions to staff that affect the public. So, for example, maybe you anticipate bad weather and an email goes out from the library director because, quite recently we all got hit with a really terrible snowstorm. Maybe the library director the day before sends out an email to all staff saying, given the anticipation for the terrible weather we're about to receive, I'm going to make the decision to close the library tomorrow to patrons, and I want you all to stay home warm and safe. Don't get on the roads. So an email of that nature would need to be disclosed because it's instructions to staff that affect the public. Final agency policies or determinations. If there's an allegation of misconduct and it's been reviewed by the people within the library that handle human resource issues, if there's a finding relating to that allegation of misconduct, the final agency determination needs to be disclosed unless you can assert that disclosure will constitute an unwarranted invasion of personal privacy. I will point out, going back to the personal privacy ground for denial, is when a public employee has been found to have engaged in misconduct, the courts have consistently, repeatedly held that records reflecting that the public employee did in fact engage in misconduct, that needs to be disclosed. If the record says, yes, they engaged in this misconduct, and yes, this is what what the discipline taken against them was, that type of information would need to be disclosed. If an allegation is made against an employee and it turns out that it actually has like no bearing in reality, there's a terrible allegation, it's investigated, and really it was just somebody with bad blood making a terrible allegation against somebody that had absolutely no ground in reality, that type of information, if disclosed, could probably very, seriously hurt the reputation of that employee and could likely be withheld on personal privacy grounds. The final intra-agency material, because I mentioned either a single agency or multiple agencies. Like, for example, if Rebecca emails me at the Department of State, that would constitute interagency material because it's two different government agencies communicating with each other. Another agency that is subject to FOIL is the Office of the State Comptroller. So if you are audited by the Office of the State Comptroller, that audit it must be disclosed in response to a FOIL request, even though it is interagency material. Certification. There are two situations under the statute where an agency is required to provide a certification upon request. The first is when someone makes a FOIL request to your library and either you just know you don't have it, it's not a record that you possess, or you think it's possible that it could have been a record that you possess, but you have conducted a diligent search and you were unable to locate it. So if someone asks for this type of certification, someone, either the records access officer or someone designated by the records access officer, would be required to certify that the library either does not possess the record or that the record could not be found after conducting a diligent search. The second certification that may be requested is someone might ask you to certify that the copy of the record that they received is a correct copy of the original. This isn't a certified copy like you might get from a town clerk or a county clerk with a seal or any sort of like raised symbol or anything like that. It's not you're not being asked, or at least you shouldn't be asked. The law doesn't require that you certify that the content of the record is accurate. You're just certifying that the copy that you give them looks exactly like the copy that, or the original that you maintain at your agency. It wasn't changed in any way prior to being disclosed. If you need to redact a record prior to disclosure, you can still certify that it's a correct copy. You would just certify that it's a correct copy subject to the redactions that we have identified to you. Appeals. In general, I'm going to just say in general, because there's always little wonky things that happen when FOIL comes into play. But in general, there are two circumstances that lead an applicant to have the right to file an administrative appeal. The first one is what you might typically consider a traditional express denial of access, an affirmative denial of access. That's where a request is made to your library. You locate the record, say, yes, we have it, but we are denying access to it in whole or in part based on this permissible ground for denial. So keep in mind, anytime you withhold any aspect of a record, even if it's just redacting a couple of words, that's a denial of access. So the records access officer, the person designated by the records access officer, would need to put in writing the reasons for the denial, and they would need to tell the individual who made the request that they have the right to appeal that denial within the 30 calendar days, and they have to advise the individual to whom that appeal should be directed. The second situation that gives rise to the right to file an administrative appeal is when there's a constructive denial of access. And that's when an agency fails to respond to a FOIL request within the statutory time limits. So your library gets a FOIL request and 5 business days comes and goes, and nothing goes out, not even an acknowledgement. or maybe you do acknowledge the request, you say you will get back within 20 business days, but for whatever reason you fail to do so. That's a constructive denial of access. Another scenario that can be considered, or at least alleged to be a constructive denial of access, is when your agency provides a date certain that you believe is reasonable given the circumstances of the request. If the applicant does not agree that the time that the date certain that you've provided is reasonable, they can challenge the reasonableness of that date. And in that circumstance, it would be the FOIL appeals officer's obligation to reassess the reasonableness of the date. They may reaffirm that reasonableness, or they may take a second look and say, I think we can get this done faster. And here's the date by which we will plan to respond. That is not a situation where the FOIL appeals officer would actually have to provide access to the record necessarily. They really just need to assess the reasonableness of the time frame when somebody is challenging a date certain that they believe to be unreasonable. The FOIL appeals officer by statute is either the head or governing body of an agency. So in general, sometimes some entities have their board of trustees act as a FOIL appeals board. That can be complicated. My personal opinion, and this is just me talking out because of my years of experience, not because it's based in statute, but having a body serve as the FOIL appeals officer is complicated because ultimately somebody needs to put something in writing. There's a tight time limit. It all has to be done within 10 business days. So if your board of trustees acting as your FOIL appeals body, they need to gather, review the records, and come to a consensus regarding rights of access, all within 10 business days. And in addition, the conversation relating to those rights of access in general is going to need to occur in public in an open meeting. Unless the conversation for any reason is confidential by statute, in general, that conversation is going to need to occur in public. So these are just sort of the problems I see with having an entire body serve as the FOIL appeals officer or the FOIL appeals body. But that's what the law says. It's the head or governing body of the agency, or, which is more common, a person or persons designated by the head or governing body can serve as the FOIL appeals officer. The only limitation is that the FOIL appeals officer cannot be the same person as the records access officer. So if the records access officer, is the business officer and they issued the initial determination, clearly the business officer cannot then serve as FOIL appeals officer. Maybe the library director then serves as the FOIL appeals officer. When you're dealing with those affirmative denials of access, it's the FOIL appeals officer's responsibility to either provide the records sought or fully explain the reasons for further denial. And then sometimes it's a combination of both those things. The FOIL appeals officer might agree with some aspects of the original determination and disagree with other aspects. Under most circumstances, the law does not contemplate a remand back to the records access officer. When there has been an affirmative denial of access where the records access officer said, yes, we have the record, but no, you can't have it, it is the responsibility of the appeals officer to review those records at the appeal level. On the other hand, if the individual is appealing because the library missed one of its statutory deadlines, it is often more appropriate for the appeals officer, unless the appeals officer is going to give the applicant all of the records that they asked for without limitation, without exception, it is often more appropriate for the appeals officer to remand it back to the records access officer so they can make an initial determination, which then can be appealed again to the appeals officer. Don't forget to send us a copy of your appeals and your appeal determinations. You're welcome to do that via email at the email address that I provided at the beginning of the presentation. Fees. This is I say this every year, is that, maybe my dream is that before I retire, I'll get everybody to understand what fees they can and cannot charge. I know this is a frustration because Processing FOIL requests can be very time consuming, but to a large extent, the time spent processing FOIL request is not reimbursable. I think that's just the mindset that most people need to understand. The actual work that goes into processing FOIL requests is not reimbursable most of the time. Here's what can be charged. That you can charge for copies. For example, if someone actually still wants photocopies, which happens less and less these days, you can charge 25 cents per photocopy for pieces of paper up to 9 by 14 inches. You cannot charge for search time, cannot charge for review time, cannot charge for the time it takes to redact records. None of that is reimbursable. If you're providing photocopies, all you can charge for is 25 cents per photocopy, end of story. If someone wants records in some format other than photocopy, which is more and more common these days, what the agency can charge is, under the statute, the actual cost of reproduction. What does that mean? Then the law goes further and explains what you can take into consideration when determining what the actual cost of reproduction. So again, keep in mind that this is just the cost of preparing a copy of the record. It is not the cost of processing the entire FOIL request, not the cost for searching for the records. It's not the time it takes to review those records to determine rights of access. It's not the time it takes somebody to sit there and either use a Sharpie or Adobe Pro or one of those redaction software programs. None of that is reimbursable. What you can charge is the time it takes to make a copy of a record. Let's use scanning as an example because it's the easiest one in my mind to sort of get my mind around. Instead of something being photocopied, they want you to scan it and email it to them. You're allowed to charge the hourly salary of the lowest paid employee capable of making that copy, but only if it takes at least 2 hours. So that's a lot of records to hit that 2-hour mark. Most times you're not going to hit that 2-hour mark. So most times, again, you're not going to get reimbursed for the cost of making those copies if the person wants them in electronic format. And if they want them in electronic format, you have to give them the records in electronic format if you are reasonably able to do so. So for example, you've got 100 pieces of paper, you put them on your multi-function copier scanner, it's probably going to take all of 5 minutes, if that, for all of those 100 pieces of paper to go through the scanner. You're not going to be able to charge for the time it took that. That is not making a photocopy, it's scanning. You don't hit the 2-hour mark, you're not going to be able to charge. If for some reason you're dealing with an incredibly large volume of records, then it's going to take at least 2 hours to scan those records, then you get to charge the hourly salary of the lowest paid employee capable of making those copies. So it makes $15 an hour and it takes them 3 hours to do it. You get to charge $45. If the records are so large, they can't be sent via email for some reason. So it's a large volume. Your email system doesn't work well with large attachments. If you need to put it on an electronic storage device like a thumb drive, whatever the thumb drive costs you at the library, you're allowed to pass that cost along to the applicant. If you do not have the technological capability of making a copy in-house and you need to send something out to a third-party vendor, maybe this is blueprints or maps or something of that nature, you are allowed, whatever the third-party vendor is going to charge you for making that copy, you can pass that cost along to the applicant. Again, you cannot charge for search time, you cannot charge for review time, you cannot charge for the time it takes to apply redactions. If you are going to incur a fee other than photocopies, you have a statutory obligation to let the person know up front what that fee is going to be, and you want to make sure that they're willing to pay it. In fact, it may be wise, although again, this is not addressed by statute or regulation, it just may be a good policy that you might want to get your money in hand, especially if it's a large cost. If you're going to incur a large cost, for example, of having something sent out to a third-party vendor, that third-party vendor is going to charge you for making that copy regardless of whether you get reimbursed or not. So sometimes it's a good idea to find out how much is it going to cost, make sure that the person's willing to pay it before you incur that cost, and maybe even get your money up front. But that's an internal decision that you need to make. Our office doesn't have enforcement authority. We are an advisory body. So I like to remind people of that, especially if you're a government employee, government official. Sometimes it feels reassuring to know that I have no authority to slap you on the wrist. I have no authority to do anything bad. My entire role is to provide you with, I've been given by statute a very limited ability to provide you with legal advice. In this very narrow area of the Freedom of Information Law and the Open Meetings Law, I can give you legal advice. So I can provide you with legal opinions or just practical advice regarding the Freedom of Information Law and the Open Meetings Law. We do not have enforcement authority. Enforcement of both FOIL and the Open Meetings Law is through a Civil Practice Law and Rules Article 78 proceeding. For FOIL, attorney's fees and other reasonable litigation costs can be awarded to the petitioner under certain circumstances. They have to prevail. They have to substantially prevail in the proceeding. And it's mandatory when they have substantially prevailed and the court finds that the agency had no reasonable basis for denying access. And it's discretionary on the part of the judge when the requester has substantially prevailed and the agency failed to respond to a request or appeal within the statutory time limits. So did pretty good about coming in right about an hour, which gives us some nice time for questions and answers. Up on the screen again is our contact information. Keep in mind, whether you have a question in your role as a library employee or a trustee, or whether you just have questions about FOIL or the Open Meetings Law in your personal life, anyone is welcome to contact our office by telephone or by email. So now I will open us back up for questions.
Thank you, Kristen. That was exactly what I was hoping for in terms of just making sure people have the basic understanding. And it's something that some folks on the line today might be thinking to themselves, I bet I never have to know any of this. But in my experience, when it does happen, you're really grateful you've got the policy, the records office manager, you know the timeline, you just know what to do. It makes it go more smoothly because a lot of times it can be someone who's not so happy with the library or feeling disgruntled about something. And when you can make that interaction go smoothly despite that, I think that's the goal that we all have for our library. So we have a number of questions that have come in so far. I think that I'm going to start off and then Brian and I will trade back and forth and then we'll flip over to the questions that got asked tonight. But the first one is a more complicated one. We thought we'd go right to the advanced level of questions to kick off here tonight. But the question, we actually have two that came in along the same lines. And it's related to kind of like an inter-board issue. When you have a library board where a trustee may foil the board itself to ask for records related to a legal advice received by the board, perhaps about that trustee who's making the FOIL request, or about the board president who may be trying, I don't know the exact situation the person was asking about, but can you speak a little bit about foiling within a board as well as foiling legal information that's been received by a member of the board from the library's lawyer?
Great question. So I'll start out by saying that library employees, library boards of trustees in general have no greater rights of access to records of the agency than any other member of the public. So even though you serve as a library trustee, under the Freedom of Information Law, you're not going to be given any more deference than if I made that same request. So you're not entitled to any other additional information under the Freedom of Information Law. That's not to say that you're not, in general, probably going to be given more records than the general public gets on a regular basis, just because you need that information to do your job. But if you start making FOIL requests because you're not getting these records, during meetings, they're not being made available to you, during the regular course of conducting your meetings. If you start instead making a FOIL request, the records access officer and the library in general is not going to have to give you any more deference as a trustee than they would to give any other member of the public. So if it's a record that would be, let's say, using that example of legal advice, they're members of a board that may have reached out to the attorney that's on retainer for the library to provide legal advice. That trustee makes a FOIL request for a copy of those communications, the emails back and forth where the legal advice was requested and provided. That's another example of a record that is confidential under New York State statute, because civil practice law and rules codifies what we all have commonly heard of as the attorney-client privilege. So when the library board or members, maybe it's certain members of the library board, or maybe it's the executive director, has asked for legal advice and the attorney has provided legal advice, that is not a record that would need to be disclosed in response to a FOIL request, even if that FOIL request comes from a trustee.
Thank you. That's very helpful.
All right, Kristen. So we're going to go to a little bit more of a lower bar in terms of asking this question. I know that you mentioned that the Committee on Open Government provides policy templates, FOIL policy templates. There are certain policies that New York State public libraries are required to have. So is a public library required to have a FOIL policy? And then without us looking at this template that's provided by the Committee on Open Government, what are some of the things that should be in that policy to help the director and board make good sense of it?
I'm going to cheat and tell you to look at the policy.
Yeah, yeah.
There are certain things like, for example, who the FOIL request needs to be directed to, who the records access officer, who the FOIL appeals officer is. Yes, the answer to the first question is yes, you're required by law to have it. So that's the easy answer is yes, you have to have it by law. Records access officer, FOIL appeals officer, when and where records can be obtained, like for example, like library hours. This is when you can come and get them if you want to come pick up. And oh, thank you, Rebecca. You're so helpful. Rebecca just popped in those a link to our model rules. Fees, the fees that we're going to charge that hopefully are consistent with what the law permits. Those are the types of things that are required to be in your policy.
And I was just going to say, like going through the slide deck that you just presented to us for over the last 16 minutes, like a lot of that is the stuff that just needs to be in there. So just tightening it up and putting it into a library policy is going to be really helpful, not only just for the board in terms of reviewing and approving that policy, but also helping staff work through some of those nuances of questions that they might receive.
So our next question is related to something you said at the top of your presentation, which is related to association libraries in New York State. You were super clear that in statute, FOIL does not apply to association libraries. But as we all know in this room today, we have association libraries that are primarily publicly funded. They're providing the same service a public library does, and they get FOIL requests just like a public library does. What advice would you have for them to manage a FOIL request they might receive to remain in good standing with their community, but also not maybe have to, I'll stop talking. What's your advice for an association library?
If your library does not meet the statutory definition of agency under the Freedom of Information Law, if you're not that public library in that traditional sense, as defined, a governmental agency, then the way I guess I would recommend, and this is me just talking, if it's something where it's like no harm, no foul, just give it to them. Like, I mean, especially when we're talking about financial records. When you're talking about things like contracts or how the library spends its money, especially if you're a library that receives a lot of public funding, if you do want to stay, have established good relationship with your library patrons, with the people in your community, I think it would be a wonderful idea to sort of not get caught up in the technicality. You can phrase it. Certainly, it may even be wise for you to include the caveat in your response that although we are not a government agency that is required by statute to respond to freedom of information laws, as a courtesy, here it is. That would be my recommendation.
Would you recommend they have a policy that says something to that effect to start with?
I think that's a wonderful idea.
Okay. Great, thanks.
All right, Kristen, what happens when there's a disagreement between the library and the community member and whether or not a document is foilable? And I think you did a really good job of taking us through the steps in terms of like what that might look like if, in the initial step, something wasn't provided. And then, we go through that vetting process of, kind of like doing a second check whether it's foilable. But like what happens when like the community, like the library is still standing strong on this is not a foilable document based on the guidelines you provide us tonight, but the community member is still in disagreement that like, no, this is a document that you should be handing over. Like who resolves that?
The courts.
Yeah.
Ultimately, it's a decision for the courts to make. That the It's always a big point of contention. We get yelled at almost somebody's always yelling at us almost every day at the Committee on Open Government because we have to remind people every day that we don't have enforcement authority. We'll get emails saying, I'm filing a complaint and I want you to tell so and so that they have to give me this record. I don't have that authority. I don't have the authority. Even if I 100% agree with the person, I can provide you with an advisory opinion that tells you, in my opinion, that that record should be available, but I can't force anyone to disclose that record. So ultimately, you make the request, the records access officer, the person designated by the records access officer, issues a determination in writing telling you why you can't have it. They should ideally point specifically to the provision of the statute that they're relying on to deny access. Um, then they're also supposed to put that in writing who you file an appeal with. Then it goes to the appeals officer. So the appeals officer then takes a second look and they have to, the obligation under the statute is either to provide access to the record sought or fully explain the reason for further denial. So while the initial determination may have been something as simple as exempt by statute, maybe someone just checked a box, and that's fine. It's, someone just checks the box saying it's exempt by statute. At the appeal level, the FOIL appeals officer may go a little deeper and explain, well, the records that you're requesting are records reflecting usage of our facilities by a library patron, and we are prohibited by statute under civil practice law and rule disclosing those. Just maybe a little deeper dive into the description. At that point, if the person doesn't agree with that determination, the obligation at that, or excuse me, their remedy at that point would be to bring a special proceeding called the Civil Practice Law and Rules Article 78 proceeding in state Supreme Court within 4 months of the appeal determination.
Follow-up question, not part of our pre-submitted questions, but can you let us a little bit into your world? Like what are some of the reasons why people are like calling your office and saying like, like you're agreeing with that maybe this information should be turned over by the local government or agency, but they're not getting it. Like why are they reaching out to you? Like what is it that they're trying to get from that local agency or government?
I think I would say the number one biggest issue that we deal with are delays. I would say that, and this is probably not really a library issue, it's a larger agency issue, whether it's a state agency or New York City or whatever the case may be. People are constantly frustrated when they're making FOIL requests and they're keep getting a pushback saying, oh, we'll get back to you next month. Oh, we still need more time. And it keeps getting pushed back and pushed back. And they even maybe someone will file an appeal and the agency will say, well, we still need more time. What are you going to do? And so the only remedy available at that point is for the person to bring a lawsuit against the government agency, which is time consuming and expensive, especially if you have to hire an attorney. So there's real frustration. And I do think that to some extent, people are reaching out to us with maybe the hope that we will have enforcement authority. They're reaching out to us not understanding that we don't have enforcement authority, reaching out to us hoping that we will yell at the agency and tell them to get their act together. Sometimes they understand that we don't have enforcement authority, but they would still like something in writing from us to share with the agency, particularly if the ground for denial issued by the agency really seems pretty flimsy, doesn't match up with what our understanding of the statute requires or what judicial precedent has held on particular issues. Something in writing from us can be really helpful under those circumstances because the government agency, again, I'm not saying that government agency is always going to listen to us, but sometimes I like to give the government credit where credit is due, and they're just trying to do the right thing most of the time. So sometimes the agency just made a mistake. They misinterpreted the statute, and getting something from us we're somewhat of a neutral, objective third party, getting something in writing from us saying, no, this is what the law requires. And please look at this court decision that says exactly that you have to disclose this record. Getting that in writing can often be very helpful in moving the process along.
Nice. Thank you.
So, Kristen, the next question that came in is actually something that happened in my own system a number of years ago, but I'm sure you've seen this in other situations. When you've got someone who's making FOIA requests at a volume and a pace that is becoming really time consuming to the agency, and really it's not necessarily, you can kind of tell at some point that the person is just creating havoc. It's not necessarily fact finding. They don't have any real plan for where they're going with this. Does the library have any recourse to cut that behavior off?
It's a conversation that we've had internally and even with the Committee on Open Government, the body, over the past couple of years. I don't think there's not other entities, other states, other countries have provisions in their statutes relating to the term they like to use is vexatious requests. I like it, vexatious. So there are states in the U.S. and I think, like for example, I know I went to a program a while back in Montreal in Canada at the federal level has a process in place for an agency when it really gets really bad. It can't just be like, oh yeah, this one FOIL request really kind of stinks. It's going to take us a couple months. No, it's got to be really bad. There's language in other statutes that address what an agency can do when they're receiving these vexatious requests. New York does not have any language in our statute about dealing with that whatsoever. Based on a plain reading of the statute, a particular individual could submit 100 FOIL requests a day, and there's really nothing in the law that prohibits them. There has been some limited case law that has dealt with harassment. FOIL as a mechanism for harassing a government agency, and it's a very minimal number of decisions that have gone down this road. So it's not a lot to rely on, but there are circumstances where the court has held that a particular agency is no longer required to respond to FOIL requests from a particular individual because they were clearly using FOIL as a mechanism for harassment. If you come to me and ask me whether something constitutes harassment, I'm not going to be able to answer that for you. It kind of goes beyond what I'm statutorily authorized to opine upon. That's something you would need to go to your internal legal counsel for. But I may also be able to help you with some strategies for dealing with specific complicated requests. So keep that in mind. Like if you get a FOIL request, like a 10-page FOIL request, or you're getting, a FOIL request every day for a month, I may just have some strategies for you to how to make your life a little bit simpler. Another aspect is letting the person know, hey, the more FOIL requests you submit to us, the longer it's going to take us to process each individual one. Every time you add more to our workload, it's that one's getting in line behind another one, and it's going to take a long time. So if you could really refocus and really just focus on the records that you really are most interested in, we're going to be able to process those requests much more quickly and efficiently for you than if you're just bombarding us with those types of requests. So hopefully that answers it a little bit.
Yeah, I think it gives people some hope. They could come to you for advice. They could also escalate it to a legal issue because I do think there needs to be some recourse. I had a library that was receiving a volume of requests where the director themselves, more than 80% of her time was being taken up with responding to these, which was truly unreasonable in the situation. So I think that's really good advice and something we hope never happens. But now you've got some folks to back you up on that.
Yeah, it is. We hear, I would say not a day goes by that I don't hear from somebody, unfortunately, that's very frustrated by, and it's just one or two people in a municipality or something that are unhappy about a decision that was made. And so they just start bombarding. I remember years ago hearing from someone who didn't even make any secrets about it. He basically told the city, I think it was the city of Schenectady, that I don't care about the records I'm asking for. I'm just going to continue to make these FOIL requests until you change your decision about some decision, some decision they had made that he didn't like. He said, until you change your mind, I'm going to keep bombarding you with these FOIL requests. I think in my mind, that's like the perfect example where I, as that city would say, okay, we're done. Take us to court. That's just me.
So Kristen, you talked a lot or talked a little bit about email communications, what's foilable. For true public libraries, how does the director working through that policy determine what can be redacted or what is actually foilable? And also now I'll build upon this question. Now that we're working in messaging type environments like Microsoft Teams or Google notifications, like is that information foilable too when it's communication between staff members?
Yes, if it's retained. So part of it has to do with retention, which is not my area of expertise.
Right.
A lot of these communications, emails, messaging, there's not necessarily any specific record retention policy that relates to those records. In theory, sometimes you could, especially when you're using like the Teams, the messaging type apps, the chat features, the Q&A on a WebEx, whatever it may be. There are some circumstances where those messages could be deleted immediately after sent or received, and there's no problem with that. If you don't have it when the FOIL request is made, well, that makes it a lot easier. And I'm not advocating for deleting everything. I'm just saying that there's not necessarily a great need for keeping every single back and forth communication that you've ever had. Yes, I will say that if you are using if you are using messaging apps, or even if you are using your even if you're using your own personal cell phone to send text messages, and those text messages relate to your public function. So, for example, we get a lot of questions about town board members, or maybe in this case, it would be library boards of trustees, where they're texting each other about library business. And the question is, are those texts records subject to rights of access under the Freedom of Information Law? The answer to that question is yes, but they're also intra-agency material. So when the second part of your question, Brian, is about, what can be withheld. If it is all internal, if it's communications between or among employees and trustees, everybody within the library, it's all going to be considered intra-agency material, but you do need to take that look at it. You can't just assume that it all can be withheld, because then you need to look to see, well, does any of it consist of statistical or factual tabulations or data? Is any of it instructions to staff that affect the public? Is any of it final agency policy or determination? I would say probably 99% of our emails and messages is just shooting ideas back and forth, right? Or even just, hey, do you want to go out to lunch later? None of that stuff needs to be disclosed. It's the stuff that really is more the formal policy making or the factual information that needs to be disclosed.
Thank you. Rebecca, do you want to rattle off maybe our last question for the night?
Yeah, so related to this, I think we would appreciate some advice on the email addresses that trustees are using for library business. A lot of the times they're using their personal Gmail account to receive information, the board packet, or to set up an arrangement with the board, or sometimes to discuss something amongst board members. Do you have advice for them? Should they be segregating that, using a different email address for library business? What's your advice?
From a practical perspective, again, this is not set forth in the statute or the regulations. It is not governed by, again, statute or regulation. I just think it's a very practical, if the library has the ability to assign library, I forget what the term is, but you know what I'm talking about, library email addresses, that's great, but that's not always possible. I understand that. In the alternative, I highly recommend creating a specific email address that you use just for the sole purpose. Like if you are a trustee, this email, I'm creating it right now. Maybe it has the word trustee in the title or whatever it is. Where you're specific, I use this email address just for conducting library business. And it's just a practical recommendation, because if a FOIL request is made for communications between or among trustees relating to a particular topic, the trustees are going to have an obligation to search their email accounts. And it's going to be a matter of trust, because the library doesn't have, it's not like the library can subpoena the trustee's computer or laptop and say, hey, hand me all of your at your computer so I can do the search myself. No, the library has to trust that the trustee is doing what they're being asked to do by searching for records that are responsive to a specific request and then turning them all over for the records access officer to conduct that review appropriately. Like, for example, it wouldn't be appropriate for the trustee to say, it's all interagency material, you can just trust me. That's not really the way it's supposed to work. It's supposed to be that the trustee turns them over to the records access officer, and then the records access officer makes the decision regarding rights of access. Maybe in consultation with program areas or with counsel, but the specific employee or trustee should not be pre-screening. You turn it over, you let someone else make the decision. By using your personal email address to conduct public business, that doesn't expose your entire computer or your entire email account to FOIL access. So if you use, like, I have, a K.A. O'Neill Gmail account. If for whatever reason, I use it for tons of things, for all sorts of personal reasons. But if for some reason I had to use it and I sent my boss an email using my Gmail account instead of my my Department of State email account, by doing that, I'm not exposing like every personal email I ever sent or received to FOIL access. It's just the specific emails that relate to my public function that are going to be accessible under the Freedom of Information Law, that are going to be records as that term is defined by FOIL. And the same is true of text messages. I mean, that's my boss and I sometimes will text each other. A lot of times we're just sending each other funny TikTok. But I mean, and that's, because, we get along and we consider each other friends. So that's not a record subject to FOIL. But on the other hand, if she and I get engaged in a conversation about something we need to do for work and someone makes a FOIL request for those records, we would need to screenshot them or whatever and turn them over to Kristen Smith, who serves as our records access officer, and that she would make a determination as to whether they would need to be disclosed or not.
Good. Thank you. That was super helpful. And Brian, I heard you when you said that was the last question, but I just really want to quickly address the question from Susan there in the Q&A about complying with a request for a patron's usage of the library if it comes from a law enforcement officer. And I just wanted to clarify that just because it comes from a law enforcement officer, it's not a FOIL request. And you do not comply with that unless they have a court order that allows you to basically circumvent the law that Kristen talked about earlier, which is the protection of the confidentiality of library patron records. They have to have basically a warrant where a court has said, yes, we will undo this law for this purpose to help with this inquiry. But if it's just a state trooper walks in and says, hey, we need to know everyone who read this book, you're not allowed to comply with that request unless they have the court order.
Yeah, agree. Thank you, Rebecca. That's, because it really is less of a FOIL issue and more of are they allowed to have this information under the civil practice law and rules? And I agree with you that absent the court order.
So we have a ton of other questions that came in, but we're at time. So what we're going to do is make sure those questions are answered in what we call our after party for the season of Trustee Handbook. But if anyone has burning questions that you need that answer right now, you can contact Kristen. She's been very free in giving her contact information. You'll have that in the follow-up email. And of course, your system staff, your local public library system staff often have these answers that you're looking for. So they can be your first stop before we bother Kristen.
Kristen,
that's our job, so don't worry about it.
Kristen or Rebecca, thanks for being here. Kristen, you're getting a lot of love in the chat, so thank you for joining us for your third Trustee Handbook Book Club. All of it was super useful and helpful, so we appreciate you taking time out of your busy schedule. And we want to thank everybody for joining us here tonight. So just as a reminder, anything that you saw, observed, heard here tonight, or any other future resources, just check out www.midhudson.org/trustee book club. That's where you can find all this information and recordings. And also additionally, please take a look at all the sessions that we're going to be offering in 2026. We have at least 3 more sessions happening in April, June, and October on the subjects of hiring and evaluating a director. I look forward to leading that discussion, laws and regulations, and duties and responsibilities of key officer roles. And then also for those directors out there, we're going to be introducing the Director Handbook Book Club, where we're going to be talking about several topics, including the new handbook, getting off to a good start, director board relations, and the library network in New York State. In the meantime, everybody, thanks for joining us tonight. We appreciate all the amazing work you're doing for our New York State Library community, and we truly enjoy making a difference with you in partnership. Be well, take care, and take care of each other. We'll see you next
Thank
time.
you, everyone. Stay warm.
Thanks, Kristen.